All right, welcome to another deep dive. This time we're going deep into something a little different.
Yeah.
Bankruptcy law.
That's right.
We're going to be looking at a couple of your sources.
Yeah.
And focusing on Chapter 7, 11, and 15.
Absolutely.
So if you're looking to understand the basics, like who can file,
Right.
what debts never go away, even if you wave a magic wand,
Right.
and why the number 18,600
Oh, yeah.
is so important
Very
to
important.
some creditors, then buckle up.
This is going to be good.
All right, so to kick things off, I got to ask,
Yeah.
why is this stuff actually important? I mean,
Bankruptcy, it's one of those things that people often think, oh, I'll never have to deal with that. But understanding it, whether you're just curious about how this side of the financial world works, or if you're maybe in a profession where this knowledge could come in handy, it's surprisingly useful.
yeah, and I think, we've all heard those horror stories of businesses going under or people losing everything.
Yeah, absolutely.
So having a grasp of the basics can definitely demystify things.
It can.
Okay, so first things first.
Sure.
There are actually 6 chapters of bankruptcy under federal law.
You got it.
But your sources focus on the big 3, chapters 7, 11, and 15.
The most common ones.
So let's start with chapter 7.
Okay.
The one most people think of, liquidation.
Right, the classic fresh start chapter.
Okay, so explain that a little more. What exactly does liquidation mean?
Well, it's basically like hitting the financial reset button.
Okay.
A court-appointed trustee comes in, gathers all the debtor's assets, sells them off,
Wow.
and uses that money to pay off the creditors as much as possible.
Okay, and if it's an individual filing, then most of their debts are, what's the word?
Discharged.
Discharged.
Yeah. Boom.
Gone.
Gone.
Like magic.
Almost.
Okay, there's got to be some exceptions.
Of course, there always are.
Like, I can't just rack up a bunch of credit card debt and then declare bankruptcy and be scot-free, right?
You're right. There are certain debts that stick around no matter what.
Okay, so it's not a get-out-of-jail-free card for every financial misstep.
That was more like a legal haunted house.
Ooh, spooky.
Where some obligations just never disappear.
Okay, so that's where this wafted mnemonic comes in, right? Our team loves these memory tricks.
Wafted. It's a lifesaver for remembering the debts that survive, even Chapter 7.
Okay, give it to me. What does wafted stand for?
All right, so W is for willful and malicious injury.
Okay, so if I don't know, get mad and take a baseball bat to someone's car.
Oh, dear.
Bankruptcy won't save me from that debt?
Nope, that one sticks around.
Okay, makes sense. Got to be responsible for your actions.
Absolutely.
What's next?
All right, A is for alimony.
Spousal support payments.
It's got it.
Okay, so you can't just dodge those responsibilities by filing for bankruptcy.
Exactly. Accountability is key.
Okay, what about F?
F is for fraud.
Okay, so trying to pull a fast one.
Right.
And it includes fines or penalties you owe to the government, right?
Yeah, especially those.
So, like, if you tried to cheat on your taxes, bankruptcy won't make it disappear.
The IRS will find you.
Okay, so honesty is the best policy.
Always.
Especially when dealing with the tax man.
Absolutely.
All right, T.
T is for taxes.
All right.
But specifically, those due within the past 3 years.
Okay, so recent tax debts.
The government wants its due, even if you're trying for a fresh start.
Yeah, I guess Uncle Sam doesn't mess around.
Nope.
Okay, 3 down, 3 to go. What about E?
E is for educational loans.
Student loans.
Those are tough to shake.
Yeah, those are notorious for being difficult to discharge.
It's a big consideration when taking on that kind of debt.
Okay, no escaping those student loans. Got it.
All right, 2 letters left in our spooky mnemonic.
Hit me.
D is for debts undisclosed in the bankruptcy petition.
So full transparency is key.
Absolutely.
If you try to hide a debt, it won't be discharged.
No sneaking past the bankruptcy bouncer.
You got to lay it all out on the table.
Exactly. And remember, wafted applies to both individuals and corporations.
So those debts are like shadows.
Do you follow you?
No matter what.
Exactly.
Okay, so this wafted thing, seriously helpful.
Glad you like it.
But I got to ask.
Yeah.
Not everyone can just decide to file for bankruptcy, right?
That's right.
There are rules.
Chapter 7 and 11 have rules about who's eligible.
Okay.
Individuals, partnerships, corporations. They're usually good, but there are some exceptions.
Exceptions.
Luckily, more mnemonics to the rescue.
All right, I'm ready. Lay them on me.
For Chapter 7, think ribs.
Ribs. Okay, I'm hungry for knowledge. What does it stand for?
R is for railroads.
Okay.
I is for insurance companies or small business investment companies.
Got it.
B is for banks.
Banks.
And S is for savings institutions.
So those types can't file under Chapter 7.
That's right. They're excluded.
Okay, so if you're a struggling railroad, Chapter 7 is off the tracks.
Exactly.
What about Chapter 11? Are the exclusions the same?
Similar, but with a twist.
Okay, twist I like.
For Chapter 11, it's BIVs. B is for brokers.
Okay.
I is for insurance companies or small business investment companies. Again,
Right.
B is for banks.
Right.
And S for savings institutions.
So same as before, except brokers instead of railroads.
Exactly. But here's the twist.
Okay.
Railroads can file under Chapter 11.
Interesting. So railroads get a bit of a special deal there.
They do.
Huh. Mnemonics really are lifesavers.
They make it so much easier to remember.
So we talked about who can't file.
Right.
But to be clear, Chapter 11 isn't just for businesses, right? Individuals can use it too.
Absolutely. It's an option for individuals as well.
Now, I got to ask about something called the automatic stay.
Oh, yeah.
It sounds kind of like a legal force field.
It kind of is.
What is it exactly?
So when you file for bankruptcy, it triggers this automatic stay, which essentially puts a giant pause button
on most debt collection efforts.
Right. Creditors can't hound you while things get sorted out.
So that must feel like a huge relief.
It does for many.
Like finally getting a moment to breathe.
Exactly. It gives them a chance to regroup, plan without that constant pressure.
Okay, but I'm guessing there are exceptions.
Of course, there are always exceptions.
Criminal
cases, paternity suits, child or spousal support, those keep going.
Right, so certain legal obligations can't be paused no matter what.
Exactly. Those are considered too important.
Okay, that makes sense. But here's a twist I'm curious about.
Okay, I like twists.
What about when it's the creditors who initiate the bankruptcy?
You're talking about involuntary bankruptcy?
Yeah, is that a thing?
It is. It's less common.
But it happens.
It does happen, yeah.
So what, it's like a group of creditors ganging up on the debtor?
Well, not exactly ganging up, but it's essentially them saying, hey, this debtor isn't paying up. Let's force the bankruptcy process.
Wow. Okay, so there are rules for this, I imagine.
Oh, absolutely. Very specific rules.
Like what?
Well, first, they have to show the debtor isn't paying debts as they come due.
Okay, so not necessarily broke.
Right, just consistently behind.
Got it.
Second, the petitioning creditors, they have to be owed at least...
Wait for it.
$18,600.
There it is.
In unsecured, undisputed debt.
So there's a minimum amount of debt at play here.
There is.
What's the other requirement?
All right, so the number of creditors involved depends on how many the debtor has in total.
Okay.
So if it's fewer than 12 creditors, just one or more owed that $18,600 can file.
Okay.
But if there are 12 or more creditors, you need at least 3 creditors who together are owed that minimum to file.
So the more creditors there are, the more need to team up.
Exactly. It's like a legal quorum.
Okay, so now I'm really curious. What happens to the debtor's property?
You mean the bankruptcy estate?
Yeah, so we're talking house, car, that weird collection of ceramic frogs. All of it goes into the pot.
Well, with some exceptions, but essentially, yes, it all becomes part of the estate.
Wow. Okay, so spill the tea. What are the exceptions?
Well, the most important one is post-petition earnings.
Okay, post-petition.
Meaning any money you earn from a job after filing, that's protected.
That makes sense. Otherwise, you'd never be able to get back on your feet.
Exactly.
What else?
Certain basic household goods are also protected.
Like clothes, furniture.
Yeah, appliances, things like that.
Okay.
The specifics can vary by state, but the idea is to allow for basic living necessities.
Right. So it's not a complete financial script down.
No, not at all.
It's about finding a balance.
Exactly.
Between giving creditors their due and allowing the debtor some dignity and a fresh start.
That's a great way to put it.
Okay, now this might sound a little technical, but
hit me.
The source mentioned the trustee being a, quote, hypothetical lien creditor as of the filing date.
Yes.
What in the world does that mean?
Okay, so it's all about priority among creditors.
Okay.
Imagine it like this.
Okay.
The trustee instantly has a claim on all the debtor's property. But, and this is important, it doesn't overrule creditors who already had a secured interest before the bankruptcy.
Okay. So if, let's say, I have a car loan, my lender still has dibs on that car, even if the debtor files for bankruptcy.
Exactly. Your claim takes priority over the trustee's hypothetical lien.
Okay, so it's a race to the courthouse in a way.
You could say that.
Whoever secured their interest first gets priority.
That's a good way to think about it.
Okay, so speaking of protecting interest, what happens if the debtor tries to get sneaky? Right, and transfer property right before filing, like gifting their fancy yacht to a cousin.
Well, that's where the trustee's power over fraudulent transfers comes in.
Okay, so fraudulent transfers. Tell me more.
If a transfer was made within 2 years of filing with the intent to cheat creditors, the trustee can undo it.
Wow, so no last-minute fire sales to friends or relatives to hide assets?
Nope. The trustee's job is to ensure a fair distribution for all creditors.
Right, so they're basically playing detective.
Exactly.
Making sure no one's trying to pull a fast one.
That's a big part of it.
Okay, this is getting juicy. It's like a legal thriller with the trustee as the detective trying to unravel these financial mysteries.
I like the way you think.
Now, the source also mentioned something about disaffirming preferences.
Yeah.
What's that all about?
So a preference is when the debtor tries to favor one creditor over others.
Okay, like paying back a friend's loan in full right before filing. But other creditors get nothing.
Exactly. It's about preventing debtors from playing favorites.
So the trustee swoops in and says, nope, that money goes back into the pot for everyone.
You got it. It's about creating a level playing field for all creditors.
So are there specific rules about what counts as a preference?
Absolutely. The transfer has to be for an existing debt.
Okay.
And it has to happen within 90 days before filing, or a year if the creditor is an insider.
Insider like family?
Exactly. Family or someone close to the debtor.
Okay, so timing and relationships matter.
They do.
What else does the trustee consider?
Well, the debtor must have been insolvent at the time.
Insolvent meaning?
Basically unable to pay their debts as they come due.
Got it.
And the transfer must have given that creditor more than they would have gotten in a normal bankruptcy payout.
Okay, so the trustee is really doing their homework.
Cigar.
Analyzing transactions, looking for any signs of unfair advantage.
Exactly, safeguarding the integrity of the whole process.
This is fascinating. So we've talked about what the trustee does, but how do creditors actually make their claims against the estate?
Right.
Do they just, like, show up at the courthouse with their hands out?
Not quite. There's a formal process.
Yeah.
Creditors, especially unsecured creditors, need to file a proof of claim with the court.
Proof of claim, so like a very official invoice.
You could say that, yeah.
Okay, and that details what they're owed.
Exactly.
What if they forget to file?
Well, if an unsecured creditor misses the deadline,
Yeah.
they might lose their chance to get paid from the estate.
Oh, wow. Okay, so creditors really need to be on top of things.
They do.
What about secured creditors? Same deal.
They should still file, but their situation is a bit different.
How so?
Their secured interest usually survives bankruptcy, even without filing a claim.
Because they have that lead on an asset.
Exactly. They still have a claim on that collateral.
Got it. Okay. So it seems like bankruptcy law is a carefully constructed system
It is.
to try and balance the rights of everyone involved.
Absolutely.
Okay, so everyone's filed their claims. It's like a financial reckoning. How does the court decide who gets paid and in what order?
It's like a financial pecking order.
Ooh, pecking order. I like it. Tell me more.
Our source lays out 3 main levels. First up are the secured creditors.
Makes sense. They had dibs on specific assets even before the bankruptcy.
Right. They get paid first, up to the value of their collateral.
Okay, but what if the collateral isn't worth enough to cover their entire claim?
Good question. In that case, they become an unsecured creditor for the remaining balance.
Oh, so they get to double dip a bit.
You could say that.
Okay, who comes after the secured creditors?
Next are the priority claimants.
Priority claimants. Okay, what makes them so special?
These are debts that, by law, get special treatment and get paid before general unsecured creditors.
Interesting. So what kind of debts get that VIP treatment?
Think SAGWEG CTI.
SAGWEG CTI. All right, you lost me. Break it down for me.
Okay, S is for support obligations.
Of child support, alimony.
Exactly. Those come first, no matter what.
Makes sense. Family obligations are a top priority.
Absolutely. Then we have A for expenses of bankruptcy administration.
Okay, so that covers the cost of running the bankruptcy case itself.
Right. Court fees, trustee fees, all that.
Yeah.
G stands for gap claims.
Gap claims. What are those?
These are new debts incurred in the normal course of business after an involuntary bankruptcy petition,
Okay.
but before the court officially approves it.
So if a business keeps running during that brief window, those new debts get priority.
Exactly. It allows them to function without those debts getting lumped in with the old ones.
That's pretty important for keeping things going.
It is.
Okay, we've got SAG. What about WAY?
All right, W is for wage claims.
So employee wages.
Yes. Wages earned within 180 days of filing, up to a certain amount.
So it's about prioritizing employees getting paid for their recent work.
Right. It recognizes that employees are often most vulnerable when a company goes bankrupt.
Yeah, definitely seems fair. Employees shouldn't be left high and dry.
Agreed.
Okay, what's E?
E is for employee benefits.
So contributions to health insurance, pensions.
That's right, but it's limited to whatever's left of a certain dollar cap after wage claims are paid.
So it's a bit of a balancing act between those two employee-related priorities.
Exactly.
Okay, and G again.
G again, but this time it's for grain farmers and fishermen.
Huh, interesting. They get special treatment too.
They do. They also get a limited priority claim up to a certain dollar amount.
Like bankruptcy law recognizes the unique risks of certain industries.
It's about taking a more nuanced approach.
Okay, so SAG-WEG, now we're on to CTI. What's C?
C stands for consumer deposits.
Consumer deposits, so like when you put down a deposit for something, but the company goes bankrupt before delivering.
Exactly. And again, there's a dollar limit to this priority.
So if I prepay for a couch, but the furniture store goes belly up, I'm not totally out of luck.
That's the idea. Consumer protection is built into the process.
Okay, that's good to know.
All right, we're in the home stretch.
All right, hit me with the last two.
T is for tax claims.
Of course, the government always wants its cut.
Always.
And finally, I.
I represents personal injury claims that resulted from someone driving under the influence.
Wow, so victims of drunk driving accidents get a special priority.
They do, which makes sense given the seriousness of those situations.
It does. It's fascinating how this priority list isn't just about cold, hard numbers.
Right.
It reflects social values, too.
You're getting to the heart of it. Bankruptcy law is about balancing financial realities with ethical considerations.
So we've got secured creditors, we've got priority claimants. Who's left?
That leaves us with the general unsecured creditors.
Okay, and they're last in line.
They are, and they only get paid if there's money left after everyone else is taken care of.
So it's a bit of a gamble for them.
It can be, unfortunately, and even then they often have to share whatever's left proportionally.
That's tough. This whole process is a wild ride.
It definitely can be, but it's designed to create a clear, predictable system for handling these complex situations.
Okay, so we've talked a lot about liquidation in Chapter 7. But what about Chapter 11? It's all about reorganization, right? How is that different?
That's right. While Chapter 7 is about selling off assets, Chapter 11 is about giving struggling businesses a fighting chance to restructure and stay alive.
So it's like a financial makeover. Instead of closing up shop, they get to try and bounce back.
Exactly. Chapter 11 focuses on finding solutions that benefit both the debtor and the creditors, keeping the business running, keeping jobs intact.
That makes sense, but how does that actually work? Do they just wave a magic wand and poof, everything's fixed?
Oh, I wish it were that easy.
Right.
It's a structured process, and a big part of it is the creditors committee.
Okay, so the creditors get a seat at the table.
Absolutely. Typically, the 7 largest unsecured creditors form a committee that advises the debtor and helps develop the reorganization plan.
So it sounds collaborative.
It is.
Which seems smart if you're trying to find a solution everyone can live with.
Exactly. It's about finding common ground.
Okay, but what about smaller businesses? I mean, that level of complexity might be overkill if they're not dealing with huge debts.
You're right. There's a simplified process for businesses with debts below a certain threshold.
Okay.
They don't necessarily need a full-blown creditors committee.
So it's a more streamlined approach.
Exactly.
Makes sense. Now, we've talked about the creditors, but what about the equity holders? Like the shareholders in a corporation?
Good question.
Do they get any say?
Yes, they do. If the debtor is a corporation, there can also be an equity security holders committee.
Okay.
Representing the interests of the shareholders.
So it's about making sure all the stakeholders have a voice in the process.
That's the goal. Bankruptcy isn't just about wiping out debts.
Right.
It's about finding a path forward that's equitable for everyone involved.
Now, in Chapter 7, the trustee plays a big role in managing and selling assets.
Right.
What about Chapter 11? Same deal.
That's a key difference. In Chapter 11, a trustee usually isn't appointed. Instead, the debtor remains in possession of their assets and continues to run the business.
Wow. So they get to stay in charge.
They do. It's a vote of confidence.
Seems like a lot of trust in the debtor to do the right thing.
It is, but with oversight from the creditors and equity holders committees.
Right, so there are checks and balances.
Exactly. The idea is that the debtor knows the business best and is best equipped to guide it through the restructuring.
Okay, that makes sense. Now I know the core of Chapter 11 is the reorganization plan.
It is.
What does that look like?
Think of it as a roadmap for the company's financial future.
Okay, a roadmap.
The debtor typically has 120 days to propose a plan.
Okay.
But if they miss the deadline or the plan isn't accepted, other parties, like the creditors committee, can step in with their own proposals.
So there's pressure on the debtor to act quickly.
There is.
And come up with a plan that works for everyone.
Exactly.
So what does a typical plan include?
It needs to be thorough.
Okay.
Cover all aspects of the restructuring. First, it categorizes all the claims against the debtor.
So putting the debts into buckets, so to speak.
Exactly. Then it outlines how each impaired class of claims will be treated.
Impaired meaning?
Impaired just means those creditors won't get paid in full.
Right, so it's about spelling out the compromises or haircuts that different creditors might have to accept.
And everyone within a specific class has to be treated the same way.
Okay, fairness is key.
Absolutely. No sweetheart deals for certain creditors.
No way.
Transparency and equality are crucial.
What else?
The plan also needs to explain how the restructuring will be implemented.
Okay, so selling assets, renegotiating contracts, getting new financing.
It's all about outlining the concrete steps to make the company financially sound again.
So it's not just about reducing debt.
No.
It's about creating a viable path forward for the business.
You got it. It's a chance for a fresh start, but it needs to be realistic and achievable.
Okay, so the plan is drafted. Who gets to decide if it's a go or a no-go?
That's where the voting comes in.
Voting?
All creditors and equity security holders who filed claims get to vote.
So everyone gets a say?
Everyone. It's like a financial democracy.
Okay, and what are the rules for the vote?
For a class of impaired claims to be considered accepted, at least 2/3 of the total debt.
Okay.
And more than half the individual claims within that class
Okay.
have to vote, yes.
So it's about both the amount of debt and the number of creditors on board.
Exactly. It needs to have broad support from the people most affected.
Makes sense. What about for equity security holders?
For them, it's a bit simpler. 2/3 of the total value of the shares in that class needs to approve the plan.
So for shareholders, it's about the dollar amount, not the number of individual investors.
Exactly.
Okay, so what if everyone votes yes?
Yeah.
Is the plan automatically approved?
Not so fast.
Oh, there's more.
One more step. Even with unanimous support, the plan still has to be confirmed by the bankruptcy court.
So the judge gets the final word.
Always, the judge makes sure the plan follows the legal rules, that it's fair, and that it has a good chance of working.
Okay, so if everyone's on board, confirmation is usually pretty straightforward.
Usually, yes.
But what if some creditors aren't...
And happy with the plan, can it still be approved?
Yeah, that's what I'm wondering.
It can, but it gets a little more complicated.
Okay.
The court can confirm the plan even without everyone's consent.
Really?
But there are conditions.
Of course.
At least one impaired class
Okay.
has to have voted yes.
Right.
And the court needs to be convinced the plan is fair and equitable overall.
Even to those who voted no.
Even to those who voted no.
So even if some folks are digging in their heels,
Right.
the court can still say, this is the best solution for everyone. We're moving forward.
Exactly. It's often called a cram-down provision.
Cram down. There's a reason bankruptcy law sounds so dramatic.
It definitely has its moments.
So the court's role is really crucial here.
It is.
In ensuring the reorganization process is fair and that the final plan is actually viable.
Absolutely.
Okay, so let's say the plan is confirmed.
Okay.
Everyone takes a deep breath. Is that the end of the story?
Confirmation is a big milestone, but it's not the very end.
Okay.
Once it's confirmed, the plan is binding on everyone.
Wow.
Debtors, creditors, equity holders, whether they voted yes or no.
So everyone has to play by the new rules.
Right. It creates a clean slate, a fresh start.
And what happens next?
Typically, the debtor starts making payments to creditors.
Okay.
According to the plan's terms.
Mhm.
Maybe reduced payments, extended timelines,
Right.
or even a mix of cash and equity in the reorganized company.
So there's flexibility in how they restructure the debt.
Absolutely. The goal is to get the company back on its feet while also ensuring creditors recover something.
Now, does confirmation discharge the debtor from most of their pre-bankruptcy debts, like in Chapter 7?
Usually, yes. But just like in Chapter 7, those wafted debts...
Those pesky wafted debts. They're like like ghosts that never go away.
They really are.
So even with a successful reorganization, some obligations just can't be escaped.
That's right.
Okay, one last question about Chapter 11.
Sure.
What about the automatic stay?
Right.
Does that protection continue after the plan is confirmed?
No, confirmation usually terminates the automatic stay.
Okay.
The stay did its job during the reorganization, but once the plan is in place, it's time for the company to operate under its new structure.
So it's a transition back to a hopefully more stable financial reality.
Exactly.
Chapter 11 is really all about second chances.
It is.
But it also comes with responsibilities and new beginnings.
It's a powerful tool for companies facing tough times. It's not a guaranteed win, but it offers a chance to restructure and rebuild.
It's a testament to the flexibility of bankruptcy law, I think.
I think so, too.
The focus on finding solutions, not just punishing debtors.
Right. It's about giving them a chance to get back on track.
All right, so we've tackled chapters 7 and 11.
We have.
Now let's talk about the last chapter on our list, chapter 15.
Okay.
This one deals with international bankruptcies, right?
It does.
Things must get really complex when you have businesses operating in multiple countries.
Oh, absolutely. That's where chapter 15 comes in.
Okay, so tell me more. What's the purpose of chapter 15?
It's designed to handle those tricky cross-border cases where a company might have assets and creditors scattered all over the globe.
So it's like the United Nations of bankruptcy law.
It kind of is. Chapter 15 is based on a model law from the UN.
Wow.
And it encourages countries to work together on these international insolvency cases.
That makes sense. You wouldn't want a free-for-all.
Right.
With everyone scrambling to claim assets in different countries.
Chaos.
So how does Chapter 15 help?
It provides a structured way for a foreign representative, usually appointed by a court in the debtor's home country, to work with U.S. courts.
So if a company based in, say, France files for bankruptcy, but they have a factory in the U.S., someone from the French proceeding can come here and participate.
Exactly. They can ask a U.S. court to recognize the French bankruptcy proceedings.
Oh.
And once that happens, they get certain powers to manage the debtor's U.S. assets.
So it's all about cooperation.
It is.
And making sure creditors in different countries are treated fairly.
Absolutely. Chapter 15 is all about streamlining the process, reducing conflicts, and ensuring a fair outcome for everyone.
No matter where they're located.
No matter where they're located. And it even has a specific rule against discriminating against foreign creditors.
So U.S. courts can't play favorites and give preferential treatment to American creditors.
Yeah, everyone's in the same boat.
Chapter 15 really reflects how interconnected the business world has become.
It does. It's a sign of the times.
Well, we've covered a lot of ground today, from the basics of Chapters 7 and 15 to the roles of the trustee, creditors, and the courts.
It's been a whirlwind tour of bankruptcy law.
It has. It's a lot to take in, but it's definitely given me a new appreciation for this complex area of law.
I'm glad to hear that. It's definitely a fascinating subject.
It is, and I know our listeners are always eager for those key takeaways.
Of course.
So what are some of the most important things to remember from our deep dive into bankruptcy?
Well, first off, remember that bankruptcy isn't a one-size-fits-all solution.
Okay.
Different chapters serve different purposes. Chapter 7 for liquidation.
Right.
Chapter 11 for reorganization. Chapter 15 for cross-border cases.
That's like choosing the right tool for the job.
Exactly. And don't forget those wafted debts.
Right, the ones that stick around even after bankruptcy.
Taxes, student loans, alimony.
Like stubborn stains.
They are.
Okay, what else?
We also talked a lot about the power dynamics between debtors and creditors and how bankruptcy law tries to strike a balance.
Right, the automatic stay gives debtors some breathing room, while the trustee acts as a watchdog to prevent fraudulent transfers and preferences.
It's like a carefully choreographed dance.
I like that.
With each player having a specific role to play.
And the court is there as the ultimate referee.
Exactly.
Making sure everything's fair, following the rules.
That's the idea.
You know, this deep dive has shown me that bankruptcy law isn't just about numbers and legalese.
Right.
It's about people facing real-life challenges. Trying to make sense of complex financial situations.
Absolutely.
And hopefully finding a way forward.
Couldn't have said it better myself.
It's a reminder that behind every bankruptcy case, there's a human story.
There is.
And speaking of finding a way forward, I have a final question for our listeners to ponder.
Okay, shoot.
Knowing what you now know about bankruptcy, how might you approach debt management differently?
Ooh, that's a good one.
Either in your own life or when advising someone facing financial difficulties?
That's an excellent question. It encourages us to think proactively about our finances and explore all the options available.
Right, whether it's budgeting, debt consolidation, or seeking professional advice.
Absolutely.
Well, folks, there you have it.
That's a wrap.
We've taken a deep dive into the fascinating world of bankruptcy law.
We have.
We hope you've surfaced with a better understanding of how this complex system works, its impact on debtors and creditors, and its importance in today's global economy.
It's been a pleasure exploring these concepts with you.
Thanks for joining us on this deep dive. We'll be back soon with another insightful exploration of a fascinating topic.
Until then,
stay curious, stay informed, and stay financially savvy.
Yeah, it can get really complicated.
Right.
But that's where Chapter 15 comes in.
Okay.
It's designed to handle these tricky cross-border cases where a company might have, assets and creditors all over the place.
Right, scattered all over the globe.
It's exactly, yeah.
So it's like the United Nations of bankruptcy law.
Kinda, yeah. It's actually Chapter 15 is based on a model law from the UN.
Wow.
And it encourages countries to work together on these international insolvency cases.
Makes sense. You wouldn't want a free-for-all with everyone just trying to grab whatever they can in different countries.
Yeah, it would be chaos.
Total chaos.
Yeah.
So how does Chapter 15 actually help?
Well, it provides a structured way for a foreign representative, usually appointed by a court in the debtor's home country, to work with U.S. courts.
Okay, so if a company, let's say based in France, files for bankruptcy, but they have a factory here in the U.S., someone from the French proceeding can come here and participate.
Exactly, yeah. They can ask a U.S. court to recognize the French bankruptcy proceedings. Yeah. And once that happens, they get certain powers to manage the debtor's U.S. assets.
So it's all about cooperation, making sure creditors in different countries are treated fairly.
Absolutely. Yeah, Chapter 15 is all about streamlining the process, reducing conflicts, and making sure the outcome is fair for everyone.
No matter where they're located.
No matter where they are.
It even has a specific rule, right?
It does.
About not discriminating against foreign creditors.
That's right.
So U.S. courts can't play favorites and give preferential treatment to American creditors.
Everyone's on equal footing.
Chapter 15 really reflects how interconnected the business world has become.
It does. It really does.
Well, we've covered a lot of ground today.
We have.
From the basics of Chapters 7, 11, and 15 to the roles of the trustee, creditors, and the courts.
It's been a whirlwind tour of bankruptcy law.
It has. It's been a lot to take in. But I feel like I have a much better grasp of this really complex area of law.
It is a complex area, but I'm glad you found it interesting.
Oh, absolutely. It's fascinating.
Good.
And I know our listeners are always eager for those key takeaways.
Of course.
So what are some of the most important things to remember from our deep dive into bankruptcy?
Well, I think, first off, it's important to remember that bankruptcy isn't a one-size-fits-all solution.
Right.
Different chapters have different purposes. Chapter 7 for liquidation, Chapter 11 for reorganization, and Chapter 15 for those cross-border cases we just talked about.
Right. It's about choosing the right tool for the job.
Exactly.
What else?
And, of course, don't forget those wafted debts.
Right, the ones that stick around.
Even after bankruptcy.
Even after bankruptcy.
Taxes, student loans, alimony.
Like those stubborn stains we talked about.
Yeah, they can be really tough to get rid of.
Okay. Anything else?
We also talked a lot about, the power dynamics between debtors and creditors.
Right.
And how bankruptcy law tries to, strike that balance.
Right. Give some protection to the debtors.
Yeah. Right.
But also, make sure the creditors get a fair shake.
Exactly. It's a delicate balance.
It is. It's like a carefully choreographed dance.
I like that analogy.
With the court there as the ultimate referee.
Making sure everything's by the book.
Exactly.
Yeah.
This deep dive has really shown me that bankruptcy law isn't just about numbers and legalese.
No, it's not.
It's about people, facing real life challenges, trying to make sense of these complex situations, and hopefully finding a way forward.
Couldn't have said it better myself.
It's a reminder that behind every bankruptcy case, there's a human story.
There is.
Well, folks, there you have it.
That's a wrap.
We've taken a deep dive into the fascinating world of bankruptcy law.
We have.
We hope you've surfaced with a better understanding of how this complex system works, its impact on on debtors and creditors,
Yeah.
and its importance in today's global economy. It's been a pleasure having you here, guiding us through these tricky waters.
It's been my pleasure. I always enjoy talking about this stuff.
Well, thanks for joining us on this deep dive. We'll be back soon with another insightful exploration
Looking forward to it.
of a fascinating topic. Until then, stay curious, stay informed, and stay financially savvy.